I'm the lead attorney for Mumia Abu-Jamal, who was arrested in 1981, not 91, 81. He's been on death row over 2.5 decades. Mumia has become a global symbol in the fight against the death penalty and for human rights. And he reminds me that he's not any more important than many other thousands of people who are on death rows across the U.S. and around the world. I think what separates him and why he's become the voice of the voiceless is that he, when he was arrested, was already a prominent radio journalist. He was heard weekly on radio programs, including even National Public Radio nationally. He, at the time of his arrest, was already recognized and described. He had the label the voice of the voiceless because he spoke out for the poor. He spoke out against corruption. He spoke out against governmental abuses. When he was, and he was convicted in 1982, sentenced to death in 1983 for killing a police officer in Philadelphia. I'm not here today to discuss the question of innocence or guilt. I think we're really concerned about bigger issues, such as the death penalty. One thing is, I think it's also interesting about him and why he has become such a symbol in this global fight against human rights abuses and the death penalty, is that from a very small cell on death row, a very dimly lit cell, he's written 5 books that are published in a number of languages. He has another book that's about to come out. I think early next year. It may come out late this year. I'm not sure what the publication date is. He continues to write commentaries each week that are broadcast on radio stations both in the U.S. and in other countries, including here in Germany, some stations. He always talks in his commentaries about issues other than himself. They're usually human rights oriented. They're about poverty, they're about women's rights, they're about the death penalty, they're about corruption, politics, issues that all of us, I think, have an interest in regardless of our nationality. And we are now, as far as where we are with the case, we are now in the United States Supreme Court. I've actually formally made an appearance in the court last month. The prosecution now has made a formal appearance, and we were waiting for them to tell us whether or not they were seeking the death penalty, seeking reversal of a favorable decision we got in a lower court. That actually this decision ordered last March, ordered a new trial on the question of whether or not Mumia should be under a sentence of death, whether he should be executed. When we had oral argument before the lower court, the United States Court of Appeals for the Third Circuit in Philadelphia, May 17, 2007, Volker was there. And we argued, discussed with this panel of 3 judges. It was like being before 3 gods. Issues of great constitutional importance. One involved the death penalty. And as I said, in March of this year, that court ruled that the death penalty was unconstitutionally applied in this case, and that Mumia was entitled to a new jury trial on the question of life or death. And since then, we've been wondering, well, what is the prosecution going to do? Were they going to try to seek a reversal of that decision? And a few weeks ago, as I said, they filed a pleading with the U.S. Supreme Court and announced they were aggressively seeking Mumia's death. The prosecution petition, what's known as a petition for writ of certiorari, is due November 19. My brief on other issues in the case, and of course against the death penalty, is to December 19. There will be cross briefs out after that. I'm not sure when the court obviously would let us know whether or not they will accept the case, but we would know certainly, I would think, by February or March whether or not we will move forward in the U.S. Supreme Court. I might point out that the Supreme Court only accepts a very low percentage of cases that are before people who petition for its consideration. We feel that we have a fairly strong chance of getting consideration on particularly one issue involving racism in the case, racism in jury selection. And the reason is that when these three judges I argued before, I and my colleagues, one of the judges dissented. And the strongest dissenting opinion I have seen in my career as a lawyer, and I've been practicing law for 3 decades and specializing in fighting the death penalty. The judge who dissented said that racism in jury selection in any case is intolerable under the U.S. Constitution, that it was blatant in this case, and there was absolutely no question but that the court should grant relief, and he strongly disagreed with the other 2 members of the court who ruled against us. So that dissenting opinion will serve as a foundation of our seeking relief in the U.S. Supreme Court. And not many people go before the U.S. Supreme Court with a powerful dissent. In effect, what that judge has done is made our argument for us. The other big issue that I anticipate raising before the court is that a prosecutor actually lied to the jury in his argument at the guilt phase. Death penalty cases are there are 2 sections of a death penalty case. First is a decision of life or death, of guilt or innocence. That's the first part, what we call the guilt phase. And then if a person is found guilty with special circumstances, it goes to the penalty phase in which a jury decides whether the sentence should be life or death. And at the guilt phase, the prosecution, in effect, told the jury that if they made a mistake, they should really err on the side of conviction because there would be other appeals, other trials, which we've argued is unacceptable because what it did is really remove the whole theory of entitlement of a defendant to not being convicted unless a jury were convinced beyond a reasonable doubt. In other words, the presumption of innocence, reasonable doubt was turned on its head by the prosecutor. Those are the 2 big issues, and of course we'll be arguing on the death penalty issue. I might point out that the favorable ruling we had by the U.S. Court of Appeals, in essence what that ruling was, that we were entitled to a new jury trial on the question of life or death. And what the prosecution is trying to do is get that reversed. If we lose, just to understand where we are in this case, if we lose on the death penalty issue and on my other issues, Mumia will probably be executed within a year. He'll be dead. Just so when I say that we're down to a life and death stage, that Mumia's life is hanging in the balance, that can be taken literally. This time next year, he could be dead. If we lose in the Supreme Court, we're out of options. That's where we are. Now, Barbara was talking about, and she gave some examples in the United States, which certainly apply in other countries too, of problems with the death penalty. The Supreme Court has recognized in some cases that, for example, someone can be executed regardless of how atrocious the crime is for sexually molesting a child, because no death was involved. The person can be in prison for the rest of his or her life, but they cannot be executed. So there have been some good decisions in the U.S., but I think this case, aside from Mumia being a symbol, representative of all the people in death rows facing the death penalty, this case kind of exemplifies why there's so many problems with the death penalty. It seems like anything that could go wrong in a case, as far as fairness, has occurred in his case. At trial, and what I'm about to mention, and I'm going to hit a few peaks, not the valleys, but what I'm about to mention happens in case after case after case in the U.S., and certainly in cases around the world where people even get any semblance of a fair trial. And in many they do not. Iran being an example, and I think Iraq even. Saddam Hussein in that show trial, that farce of a trial that he went through. Mumia did not have any money to hire a lawyer. He did not have money for an investigation or for experts. The lawyer who represented him, Tony Jackson, who recently died this past year, did not want to be in the courtroom. He asked the judge to relieve him of the case. The judge would not. Because Tony had asked for money for an investigation, the judge gave him $150. When I do a death penalty case, I mean, that's all I do, we spend tens of thousands of dollars on investigation, in any case. I have cases where, $50,000, $75,000, $100,000 just for an investigation is not unusual. Same with experts. There just wasn't the funds in the case for an investigation, so there was no pretrial investigation. There were not funds to employ experts in such fields as ballistics, which is crucial in this case, pathology, which was another crucial area in this case. None of that was done because Mumia had no money. He was poor. And again, this is more the norm than the exception in the United States, and I think everywhere. I mean, a warden once said in the United States many years ago that the death penalty is a privilege reserved for the poor. And Exhibit A would be Mumia Abu-Jamal, what happened at his trial. On appeal, the attorney appointed to represent him on his direct appeal, she did what she could, but it was far below what I and other people who specialize in death penalty litigation would consider acceptable representation. In the 1990s, a group of lawyers came into the case who supposedly knew what they were doing. But they made some horrendous mistakes that we are suffering from now, and Mumia could be executed because of the mistakes of the lawyers. I'll give you an example. And again, this is, when I talk about Mumia, this happens in other cases, thousands of cases. This is not unusual. One of our issues in the case involves the prejudice of the trial judge, who was heard by a court reporter during a recess in the 1982 trial, referring to Mumia in the most despicable manner possible in the United States. His words were, he said to another judge as they passed each other in an antechamber hallway, judge said, "How's the trial going?" And Judge Albert Sabo, the judge in Mumia's case, said, "I'm going to help them fry the nigger." That's just, it's atrocious that a judge would be trying a person, a black person, in an American courtroom with that attitude about the person on trial, the defendant, and also to refer to him in such a despicable racial manner. The lawyers, when they raised this issue on appeal, now I wasn't involved in the case then, accused the judge of being prejudiced at a hearing, a post-conviction hearing in 1995, 13 years after the trial. What they did not do is also include that he was prejudiced at the trial, the 1982 trial. And the U.S. Court of Appeals denied I raised that issue about the prejudice of the judge, and they said no, you can't get a new trial arguing that a judge was unfair 13 years after the fact, after the trial. You have to accuse him of being, him or her being prejudiced at the trial. And when I took over the case 6 years ago as lead counsel, I inherited, the die had already been cast as far as the issues we could pursue. And so I cannot get around that. And so this major issue about the prejudice, the racism of the trial judge at the trial will not be considered by any court because of the lawyers not raising the issue. It's not Mumia's fault. He did not even know till I took over the case. The lawyers had not told him that they screwed up on this, but they did. I'll give you another example. The big thread that's run through this case from the beginning, when Mumia was arrested December 9, 1981 through today, has been racism, which is not unusual, again, in American capital cases. There's an inordinate number of black people who are prosecuted and sentenced to death and executed in the United States. Racism is a fact of life, unfortunately, at least in the U.S. One of the big issues, or the biggest issue we have, is the racism in jury selection by the prosecution. In other words, the prosecutor was systematically removing people of color from sitting on the jury. He used nearly 70% of what we call strikes to remove people who were black from sitting on the jury. U.S. Supreme Court has held that that's unconstitutional. In a case, the name of it is Batson versus Kentucky. The problem is that this jury selection process was from a larger panel of jurors. When I made the oral argument, Volker Reitzman was there last year, and before this three-judge panel, and I had all these arguments about evidence of racism in jury selection. And there was one problem I had, and I was hoping we could overwhelm them with other evidence. And one of the judges asked me, I don't know if you remember this, Volker, one of the judges said, well, Mr. Bryan, what was the racial composition of the panel, what we call the venari? And a chill went down my spine because that was our Achilles heel in this case. Because the lawyers who represented Mumia in the 1990s did not get the racial composition of that jury and put it in evidence. And it would have taken, they could have done it in a day or less. We're talking about 50 people, just determining what their race is. Go knock on their door, see if they're white or black. And the reason that was important to the judges, and in their decision denying relief in March of this year, they went on and on, kept repeating, we do not, Mr. Abu-Jamal, petitioner, did not, well, they mean his lawyers, but they refer to him, did not present evidence as to the racial composition of the panel. So we don't know in context, all right, the prosecutor used 70% of his strikes. It was about 66, 67, or let's say 70 for discussion purposes. He removed people of color. But that has to be taken in context with what was the racial composition of the panel. If it was 90% black, then a 70% strike rate may not mean anything. But if the racial composition of the panel from which the jury was selected was, say, 10%, then a 70% strike rate would be astounding. I mean, that's just pure racism. You could cut it with a knife. But we do not have that. Now, I hope, and our dissenting judge said he felt that there was plenty of other evidence, which we had presented, to show that that racism was alive and active in jury selection in this case. In other words, we should get relief. But my point is that this is an example of somebody who could be dead in a year at the hands of the executioner because of his lawyers, which to me is shocking to the conscience. And it happens. Many people, and I'm sure Barbara and Volker and Andrea and other people in this room are aware, many people go to the gallows, if you will, the death chambers in the United States because they had bad lawyers. And the rules are, now I will say this, Mumia first asked me to represent him over 20 years ago. And in 1985, he and his family started contacting me. And finally, in 1991, when it was at the point where we started thinking about going into federal court, I just told him I could not do it. I was too busy, and I was with other death penalty cases. And then he came back to me six and a half years ago and asked if I'd take over the case because it was such a bloody mess, and I did. But this case is just, I think, a terrible example of a person who's sitting on death row because he's black, because he's politically outspoken. Now, neither of those two have anything to do with the crime or anything he's done wrong. But he's black. It's a factor against him. He was a politically outspoken journalist who the authorities said in Philadelphia they would get someday because he was causing too much trouble. He was convicted of killing a white cop, which is the worst case scenario, a black accused of killing a white person, and that person then being a cop. And certainly as Amnesty has demonstrated in its extensive research on case after case after case, that there's a pattern that people who are black convicted of killing white people are much more likely to receive the death sentence and be executed than a white person convicted of killing another white person, or particularly white person convicted of killing a black person. He's a person who's poor, major factor in him winding up on death row. He did not have good counsel, good representation at trial. I mean, these are all common factors of why people wind up on death row and wind up being executed. If you will, this case is a smorgasbord of what's wrong with, I think, the death penalty and how things can go wrong in an American courtroom. I would like to point out one other thing. I mentioned a little bit, alluded to politics. The authorities said they wanted to kill Mumia, and they got their chance. And they also thought because he was so well known as a journalist that by putting him on death row, they would shut him up. The reverse happened. When he got on death row, he began to do these commentaries and started writing a lot. And today he's much more well known than he was when he was arrested. And the attitude of the government is that the way to shut up Mumia finally is to kill him. And that's what this is all about. And the prosecutor had announced in March, she had a press conference the day of the federal court decision when we won on the death penalty, that she would not rest until he were dead, that they wanted to see him executed. And that's what all of this is about, is a long-planned attempt, premeditated attempt to kill Mumia Abu-Jamal. And that's what happens in all these cases. The state is planning with great premeditation to kill another human being in the name of God. They always invoke God and the state. So anyway, I think that's about all I have to say. And Mumia is, I might point out, he was elected last year into PEN, P-E-N, which is the oldest human rights organization in the world. I think it has 144 chapters throughout the world, including one here in Berlin for Germany. He's the only death row inmate who's a member of PEN, a regular member of PEN. Nicole, the better half of our family, had been after me for a couple of years to apply, do an application for Mumia to become a member of PEN. I finally did it last year. Salman Rushdie was involved behind the scenes in helping Mumia become a member, because it's very unusual. I mean, he certainly was qualified as having written 5 books, but you know, his address is kind of unusual, death row in Pennsylvania. Alice Walker sponsored his application, E.L. Doctorow, a number of important people. And I remember the day that Mumia was accepted. I received a letter that he was accepted into PEN. He and I were talking on the phone, and he's not normally a very emotional person, and he, I think he was crying, because he said, "Do you realize this is the first time in my life that finally I'm being accepted, not because I'm a well-known political prisoner, but because of my craft of being a writer. I'm accepted by people like Norma Mailer and other writers. And he said, you have no idea how much that means to me to be accepted as a writer.